Hello, my name is Elias Nassif. I'm an IP and competition associate at Al Tamimi & Company, here to briefly highlight and discuss the importance of considering the applicability of the competition law in IP licensing arrangements, specifically trademark licensing arrangements. IP laws accord authors or owners of IP exclusive rights over such IP assets. That is, the IP proprietors are given the exclusive right to dictate if, how, and by who their IP may be used. Now, these are usually determined pursuant to a licensing arrangement in accordance, obviously, with the respective IP laws. Now, part of the common and essential terms of any IP licensing arrangement is the quality control provisions. Essentially, that is, those provisions that seek to preserve or maintain the quality or reputation of IP assets. By way of example, if we look at the UAE Federal Trademarks Law, the law expressly allows for trademark licensing arrangements to limit the marketing of goods or services bearing the licensed trademark to geographical territories. And amongst others, it expressly allows for the licensor to impose obligations on the licensee relating to the quality control of the product bearing the trademark in question. Now, given such broad powers or rights, some may readily impose such conditions as a means of ensuring quality control, without realizing that such IP rights are not absolute and, if left unchecked, may contravene the restrictive agreement and abuse of dominant position provisions in the competition law. Whilst both the IP and competition laws have the same underlying objectives of incentivizing innovation, furthering dynamic competition, and ensuring consumer welfare, they seek to attain such goals through apparently conflicting means. That is, the IP law grants exclusive rights to IP rights holders to this end, and the competition law serves to regulate such rights to the same end. Prime examples, as I mentioned, which stand out and need to be considered in this regard are the restrictive agreement and abuse of dominant position provisions. Now, the former refers to agreements which have as their subject or objective the abuse, restriction, prevention of competition, including but not limited to direct or indirect price fixing, setting conditions on the sale and purchase of goods or performance of services, also market or client allocation based on geographical areas, distribution centers, quality of clients, seasons and time periods, or anything really that affects competition. The latter, the abuse of dominant position provisions, refers to situations where parties to an agreement are in a dominant position in the relevant market concerned. That is, when the shares of any of the parties exceeds 40% of the total transactions in the relevant market in question, or in a substantial or influential part thereof, and then abuse their dominant position to undermine competition. Some examples of this may also include directly or indirectly imposing prices or conditions on the resale of goods or services, predatory pricing, forcing a client not to deal with a competitive establishment. Now, these examples constitute some of those common provisions found in trademark licensing arrangements, which, unless exempt, would constitute a breach of the competition law. So, by way of example, again, common trademark licensing arrangements that may contravene the competition law include directly or indirectly fixing prices on the sale of goods or services bearing the licensed trademark, also restricting or limiting the sale or supply of other goods or services not bearing the licensed trademark. You have restricting or limiting the supply of goods or services bearing the licensed trademark to certain geographical locations or time periods. You also have obliging licensee not to license or sell or distribute other goods or services. Of course, there are many instances where such agreements will entirely or partly be exempt from the competition law, such as if the parties involved are considered small or medium-sized enterprises in accordance with Cabinet Resolution number 22 of 2016 on the definition of small or medium enterprises, or also if the parties to agreement or the agreement pertains or relates to an exempt sector, such as telecommunications, pharmaceuticals, transport, amongst others, and other exceptions. However, to ensure you are not in contravention of the competition law, this is something that must nonetheless be considered. failing which parties may be exposing themselves to the wide array of the severe penalties within the competition law. So you have substantial fines of up to 5 million, so around 1.3 billion US dollars, and the closure of business premises for a period of between 3 to 6 months. Please feel free to have a look at my article on this matter entitled Walking the Tightrope, Delineating the Inherent Conflict Between Intellectual Property Rights and Competition Law in Trademark Licensing Arrangements. Our IP and competition team are regularly, of course, advising on such matters and happy to assist with any of your queries. I hope this was insightful and hope you continue to stay well and safe. Thank you.